Hello everyone, and welcome to this month's Contract Administration Practice Group. I want to hand it over to Jim and Douglas to do any more introductions before we get started with today's presentation.
Welcome everyone, this is Doug Freeman. We, as you can see, are going to be discussing claims and disputes management today. We have a lot of material, so we may not get through all of it today and may roll over into next month. Jim?
Just echo Doug's welcome. Glad to have you here with us. Please do raise your hand to Matthew so we can get your input here. And just to get us started, we are talking about Chapter 10 in the Practice Guide, Claims and Disputes, and that starts on page 201 if you're trying to follow along in the Practice Guide. So let's go ahead and get started. The slide you're looking at now defines where typically the claims would come from on a project. These sources include those claims that may be filed by the contractor, and of course those would include the people that the contractor represents, whether that would be on behalf of a subcontractor or a supplier, and these of course would be claims that were filed against the owner following their contractual agreement. There may also be claims filed by the owner against the contractor, again following the path of contractual obligation there. And a third type, which is not so typical but sometimes happens, are claims that may be filed by others that are not a party to the construction contract whatsoever. And we're going to go into each of these and talk about them a little bit. So Matthew, if you will, let's take a look at contractor claims, the next slide. These are some of the examples of why or about what claims would be filed from the contractor. Potentially, there may be active interference by the owner or the architect or engineer. That these might be defined as interruptions in construction sequence, where possibly decisions weren't made in a timely fashion, and they weren't able to stay on track with their planned work. There may be conditions beyond the contractor or owner's control that might encourage the contractor to make a claim. A brief example I've had in the past is material that was being shipped to the job being lost in a vehicular accident and damaged beyond the purpose of use, so it had to be remanufactured and reshipped. That might be an example of the basis of that kind of claim. Potentially unforeseen conditions that affect the extent of the work, and we have a host of potential items that may be, whether it's unsuitable soils or things discovered under the ground that no one knew were there, abandoned wells or storage tanks, etc. That also might result in a claim. There could be modifications made to the contract documents, things that changed either at an appropriate time or potentially changed in between bidding and construction. There may be any host of modifications that could have occurred or that need to occur as things are discovered on the site. And we'll talk a little bit further about interpretation of what might really be a claim and what might not be a claim, or what is really substantive change in the contract documents. And then last but not least, there may be errors and omissions in the documents that would in the contract documents that would result in some claim for the contractor. Doug, are there things to add here that you know?
I just wanted to mention that for our purposes here, when we refer to a claim, we are generally referring to a request for an adjustment to the contract sum or the contract time.
There you go. Okay, well, let's take a look at owner claims, Matthew. Next slide. Some things that may result in an owner having a claim might be a correction of nonconforming or defective work, something that's been discovered during the contract sequence that has to be redone or undone, or potentially is discovered after construction is complete or towards the end of the project where some defective work had to be removed and replaced or repaired. There may also be repair damages that occurred. There may be existing property associated with the project where something has happened adjacent to or within the perimeter of the defined construction site where damages occurred. But heavy equipment may have struck something or caused damage to pavement or sidewalks, that kind of thing. And then there are claims for liquidated or compensatory damages where the owner was affected in some fashion and the contract allows for an adjustment in the contract cost because of those damages or delays. And then there may be claims for ineffective project management. Whether it's the process of the shop drawing and reviews, where that might be something that the architect has notified the owner. They're making multiple reviews of shop drawings and submittals. There may be multiple substitution requests that have had to be processed on the job. This can involve the designer. It could also involve the owner's personnel in considering requested changes. There may have been interferences with the owner's operations, again, if there's an existing facility or property where other things are ongoing during the construction sequence, and potentially additional visits and administrative time, again, both from the owner's personnel and the architect and engineer having to perhaps visit the site more frequently because of lack of pre-planning. Testing agencies that come to the site to test work that are not notified not to come for a day because of weather or because of some other change in sequence. So these all represent things upon which the owner may face a claim. Doug, anything to add to that list?
No, I think that pretty much covers it. We can see if anyone in the group wants to add to either of the two lists that we've gone over so far. If you have a comment or want to add something, please type in a message or do a tweet so Matthew can let us know.
Matthew also is...
Nope.
Go ahead.
Just going to say, I don't have any questions as of yet. I'm checking the tweet chat as we speak right now.
While you're doing that, let's take a look at the third-party claims. These are of course not typical with projects, but can involve either adjacent property owners or individuals that have some perimeter involvement with the project, either nearby or directly adjacent to. And it may involve interests of the parties that are not contracted with the construction. And sometimes can involve injury or death to those people or damages to that property. Doug, do you have any?
An example of one of those, we were working on a project in a downtown area, and our site happened to be next to a car dealership. So the contractor is setting up to paint this building. It was a sports facility, so we had exposed steel outside that was being spray painted. The next day, the site was visited by the general manager at a car dealership. All of his cars became polka dot. The overspray drifted across the street and landed on many of the vehicles in his parking lot. So that is one example of a third-party claim. It's this adjacent site. The person making the claim had no relationship to the project, and it was property damage due to the work of the contractor.
And I would add, if the participants have any kind of stories or examples to share, please do raise your hand and let Matthew know so we can talk about those. I've heard Doug's story, and airborne paint has had its fair share of third-party claims. So if there are any stories that you may have, it'd be great to get them here for us to talk about or to consider. So Matthew, let's go to the submission of claims. We've talked about the three sort of categories. Let's talk about the submission process itself.
And Jim?
Sure.
Before we get started, Kevin just wanted to let everybody know from his point of view, the third-party claims are not typically covered under the terms of AIA and the EJCDC based construction documents, but still obviously need to be handled in some manner nonetheless.
That's right. Well, you know, in bringing up the documents themselves, the AIA documents state that the claims are submitted to the initial decision maker. That may or may not be the architect. There's an opportunity to decide who the initial decision maker is during the process of putting the contract documents together. Many times, though, it is the architect. The EJCDC documents currently state that the claim is submitted to the engineer. And I think Kevin had some information that he wanted to share at this point of our conversation. Kevin, you want to go ahead and do that?
And can we unmute Kevin?
Hello, this is Kevin O'Byrne, and the little automated voice in my ear just said I'm unmuted. At EJCDC, we've just completed a comprehensive update of EJCDC's design, bid, build series of documents. They should be released and available for public use, hopefully sometime within about a month or so from now. And in the process of updating the C700 standard general conditions, there's a number of changes being made now to the process of contract changes and the claims procedure. In the past, it was very similar to the process set forth in AIA A201. Going forward, however, we recognize the need to define a way for the parties to amicably negotiate a change in the project without resorting to filing of claims. It's my opinion that this was typically done anyway, although if one wanted to formally define it, you had to write your own Division I spec section that set forth the process. Whereas, you know, in the current 2007 edition of EJCDC C700, really the only way memorializing the general conditions is to go right to the claims process. And since a contractor's record might appear to be somewhat checkered if he has a long history of claims, some owners may prefer to not perhaps do business with a contractor with a history of a lot of claims on a project. We decided at EJCDC that we would define a process that's kind of similar in certain effects to the current claims procedure, but it's at a lower level and it's not really called a claim yet, in which proposal request is prepared and submitted, and then a change proposal is submitted back, and so forth. None of that's terribly interesting, except for memorializing it in the general conditions. But once a claim is filed by either the owner or the contractor, we ultimately saw fit this time to essentially remove the engineer from being the initial decision maker in the claims process. The documents is set up right now. They don't have an entity called the initial decision maker, or have defined the engineer as determining entitlement in a claim. The rationale being that the parties have already attempted to amicably negotiate the change through the change proposal process. The engineer has already made some kind of a decision at that point. What's the point of escalating it to a claim where the engineer or initial decision maker gets another bite at the same apple? So the process is defined as, going forward, the owner and the contractor would negotiate directly with each other. And I think this also kind of has the added advantage of probably escalating it to higher level personnel in the owners and contractors organizations, and also it removes the engineer from that somewhat difficult position of trying to both serve the owner's representative, and of course the owner pays the engineer's bill, and then the engineer in some cases having to determine entitlement in a claim against the owner. A lot of owners, I guess, might not fully appreciate that type of impartiality and get a little upset with some design professionals when they rule against the owner in a claim. So this allows the engineer to really serve truly only one master. And I guess in a certain way it is slightly reminiscent of the claims process set forth in consensus docs. But the idea is that the parties are probably more likely to reach a negotiation settlement that's mutually acceptable to the parties before they go to dispute resolution, if they just simply are negotiating directly with each other. And often, at least in public works, we've often seen that winds up happening anyway. You know, owners and contractors have not always followed the claims procedure in the contract document. They sort of feel compelled to just sort of sit down with each other, and may or may not always invite the engineer to the room. So now we're formalizing that process. So a few changes in the claims process and the way changes are negotiated coming up in EJCDC C700, available in about a month or so.
Kevin, thanks for sharing that. So we got a advanced preview of the new EJCDC documents.
I'll tell you something that is exciting to me, that I think that this exact example is what is so wonderfully cool about these practice groups, that there's timely information shared between professionals that is brand new. Like Doug said, Kevin, thank you so much for letting us in on, not the secret, but on the cutting edge of change, because I think that's what we have to do as a profession to service our clients in really the way that we want to. You know, you touched on some things that I would like to just follow up on, and Doug, I want to give you a chance to do that too. The very first one that, you know, Doug and I have talked about so many times is communication, and just talking, not emailing, not letter writing, but just communicating and talking about the status of the project and how things are going. There's no better substitute for direct communication, and we'll talk later about how to avoid claims and disputes, and this is a piece of that. You know, and the other thing you touched on that's difficult is this position of being an impartial party. You're supposed to represent the truth and the facts and let things sort of fall as they may. And it is a difficult position for the engineer, for the architect, to look at the owner and say, yeah, you know, this contractor's right. This really is something that they ought to be paid for, and have them accept that in the fashion it was intended. And the last thing I wanted to say, you know, it's interesting that the way that you're modifying the documents. There was a time, particularly for public projects, when there was a bonding company involved, that you had an opportunity to communicate, maybe call the bonding company of the contractor and say, things are not going well here. We don't want to get into a claim situation. And the bonding company would have some positive response about getting involved, as you were describing, Kevin, and trying to head off things. Seems like now the response is, have you filed a claim yet? And so I'm hopeful in what EJCDC is doing that perhaps we can help the industry move in a better direction than they seem like they've been in lately. Doug, anything you want to?
Yeah, to piggyback on that and what Kevin said, that initial decision maker position is a precarious one. The AIA general conditions state that the architect is to be neutral, impartial when acting in that role. As Kevin mentioned, sometimes that's tough to do, especially when the owner's paying your bills and he's looking at you, expecting you to rule on his side. I wanted to point out, in North Carolina, our licensing laws also have that requirement in there, so it's not just a contractual requirement. Let me read what it says here. When acting as the interpreter of when acting as the interpreter of building contract documents and the judge of contract performance, an architect shall render decisions impartially, favoring neither party to the contract. So at least here in North Carolina, you are legally obligated to be impartial as well as contractually obligated by the contract documents when you're acting in that role as initial decision maker. So you need to be careful when you're doing that.
Well, let's go ahead. So in the submission process, of course, there's a required notification to the parties that are involved, and there are time limits for these notifications for the submission of a claim, and those are typically defined in the general conditions to the contract. Certainly, one of the important items is to be timely in the process of claim submission, to do it in writing, and not to let those accumulate or delay until the end of the job or towards the end of the project. It's important for parties to know that there's a claim situation as soon as that situation occurs. And as Doug said earlier when we started, when a claim is submitted, then that submission should include the monetary costs and also any additional time requests that are associated with that claim. So it's important to have that be a full package. This is typically how claims are submitted. Doug?
As Jim and I discussed when we did our discussion on change orders a while back, the resolution of those claims after they have been submitted need to be done timely. You do not want to wait and let those build up. You need to jump on those and get them resolved as soon as possible. Another point to make here is the general conditions have those notification requirements and timelines. The courts are generally going to enforce those requirements. I have seen case after case where a minor notification requirement was not followed and the court said, well, you didn't do what you said you were going to do in the contract, and they dismissed the claim. You wait, you're supposed to notify 21 days within the occurrence of the event, and you've talked about it, but you haven't given an official written notification like the contract documents say. The courts will say, well, yeah, I know the owner knew about it, but you didn't follow the procedures and give him something in writing. So you need to be aware of what those notification requirements are in your contracts and make sure that you comply with those to the letter.
That's a great segue, Matthew, into the next slide, and I'll just say if you go to the practice guide and look at page 205, it's figure 10.1, and it's sort of a diagrammatic representation of claims and how they're processed, how they're filed, and the resolving or the settling of those claims. As Doug just said, the procedures are contractually based. They're spelled out in the contractual agreement, but they should be timely. The claims should be managed equitably and in a timely fashion. So in the process of resolving or settling those claims, first, of course, you would review the contract documents and determine whether or not there is, in fact, entitlement. We're going to talk about what exactly entitlement is in a minute, but we want to go through the process of resolution first, and we'll define entitlement in just a second. So let's assume that entitlement is established. Then how do you go about adjusting things as they're stipulated in the contract documents? How do you adjust the cost or the time? Well, first, very important is obtaining the proper documentation, all of the supporting material, which would include anything that is related to this issue, written or photographic, and a real thorough understanding of the claim. I've seen occasions where folks got really excited and took off half-informed and made some bad decisions because of that. So first is actually understanding, having the proper documentation and understanding what the claim is centered around. And then once that information is gathered, reviewing that information as a package and then accepting or denying that request with proper justification needs to be done in a really timely fashion. As you're reviewing, you need to confirm that the compliance of this claim with the contract documents. Are these changes that we had unit prices established for? Do we have lump sums in our contract that apply to this situation, so that the contractual cost methods that you have in your contract are complied with? And then review and accept or deny any schedule modifications or implications. So at the same time you're looking at the costs and what impact that may have and whether you accept it or deny it, there's a separate component for the schedule. There may not have been the schedule impact that is noted in the claim, and so there may be cost associated but not time. Those things are independent reviews. If there is something that is being independently tested or sampled, whether it's site work involved or some sort of removal that is in progress, obtaining those independent samplings or tests that would define work as defective or non-conforming, or that's in compliance. We had unsuitable soil that had to be removed and replaced, and everything complied with that. Being sure that you have that information together is critical. And then any additional site observations or visits that you need to make with all of this information in hand, or all of this in your head that you've now learned about the claim, going to the site as you need to familiarize yourself with the details of this claim are critically important. So Matthew, sure.
I'm sorry, Jim. The claim needs to be complete when you receive it. So if there is a cost implication and a time implication, you should get all that information together as one claim for that one occurrence. If they're independent of one another, then you would handle them separately. But if the claim is that the owner interfered with my work, he had his crews out there in the way so I couldn't get my work done, it's going to cost me money, general conditions, and time. I need a contract extension. You need to get that together. If it's a soil situation where we ran into rock, we didn't know the rock was there, It's going to cost more to remove the rock, and it's going to take us more time to remove the rock. All of that comes together. You don't get a proposal or a claim for a rock and then 2 weeks later get a claim for the time to deal with the rock.
There you go. So Matthew, let's go to the next slide. Once all of this information and due diligence, this information has been gathered, you've gone through everything that you should, you need to, and it's ready then for you to render a thoughtful decision that is in writing. And that would be the answer to the claim for you, the architect or engineer, the decision maker. Now, as maybe many of us have had happen, all the parties that are involved with the project can, if they mutually agree to do so, waive some of these requirements that we've been talking about and allow for a negotiated compromise, a solution or settlement to the issue. And of course, that's a possibility and could occur at points in your review and rendering of a decision. But if that is something that's done, then those actions should be based on reasonable expectations, and they should be undertaken with professional and ethical behavior. Again, going back to the impartial and fair and factually based decision maker is critical to have as a filter for all of this information. Doug, is there anything you want to add about rendering a decision there?
No, I think I'm going to wait. I wanted to say something, but I'm going to wait till a little bit further in the presentation. So let's, okay. Matthew, let's move on to the next slide.
So we talked about entitlement, and what is that? As defined, the right to benefits specified by law or contract. So the contractor entitlement is first established by deciding whether or not that work was reasonably inferred in the contract documents. So was there enough information there? I know you all have experienced the conversation about the plans and the specifications serving as a total description, and one is not necessarily taken in place of the other, but they work in concert. So was the work reasonably inferred within the contract documents? And if the answer to that is no, it really isn't, then the claim may be a valid claim, and you may have established entitlement. The second step to establishing this entitlement is, as Doug was just saying, the timing of the claim. Did it come in a timely fashion? Did it come before the work was done? Did the owner have an opportunity to think about another way that this may be accomplished, whether that might be redesign, relocation, work performed by their own forces, and really have the opportunity to consider whether this was a cost-effective action or not. If the answer to that is no, the claim may be invalid because that too is a portion of the contract document requirements in submitting a claim. So these are considerations for contractor entitlement. Matthew, let's take a look at the next slide for owner.
Jim, hold on before we move on. This reasonably inferred term is a tricky one, and it's subject to interpretation. Generally, I would say what you need to look at when you're considering that is, is the work that is the subject of the claim, is it something where it would be customarily included. So say it's not clearly spelled out in the documents or in the specs, but is it something that would customarily be included? If the answer to that is yes, then I would say yeah, then you could reasonably infer that that was a part of the scope of work. Is it something that's necessary for the work to be completed? Would be something else to look at. Industry standard. Is the standard in the industry for this to be included or not to be included? So that reasonably inferred term, again, is subject to interpretation, and that's where you may have a rub where you're saying, based on my documents, you should have known that you needed to do that, and the contractor saying, well, it's not there, I didn't have it in there. That's kind of sticky. There's not really any good guidance out there, but if parties are being fair and upfront with each other, you can usually work through that kind of stuff. The timing issue, again, is important. If you wait on claims and as the project's moving along, you ran into something with unforeseens in the soils, but you don't submit a claim, the contractor doesn't submit a claim to the owner, and the owner's moving along, and then he's making a decision, well, you know, I've got my contingency over here, we're halfway done, I haven't used any of my contingency, I'm going to upgrade some finishes. And then he gets hit with the change order for something that happened 6 months ago with some unforeseen soils conditions. And he's made his decision based on the information he had at that time when he didn't know about this soils condition that happened 6 months ago. So that's why the timing of getting those claims in is important, and why courts will strictly enforce those timing provisions and those notice requirements, is because the owner has a right to rely on and make decisions as that project's moving along, and he can't make an informed decision if there's a claim out there that he's not aware of. So Matthew, let's go to the next slide and take a pause, because we haven't done that in a while, to see if there's any comments or questions from any other participants. Matthew?
I don't have anything yet. I'm just checking to see if anybody's typing now that they have an open mic here. No, it looks like you guys might be ready to go on.
Thank you.
Okay. You know, one of the things that Doug just touched on that we talked about earlier, there are opportunities for the group to undertake agreements outside of the contract documents if they so choose, and I think it's important to stop and think about that for a second. In Doug's experience, when the contract documents are followed, there is a tight case to be made for perhaps not reaching a quick agreement to circumvent the circumstances that are spelled out there. And let me just say it this way. Sometimes parties are quick to grant time or to grant additional monies to avoid the process. And I have seen where that circumstance had worked out in the contractor's favor when, if folks had been willing to go through the procedure, maybe it would not have worked out that way, and the owner could have saved additional time and money. So having things well documented and having timely responses to issues, and just as importantly, documenting from whatever party that there haven't been timely responses to issues may be in the owner's favor. And so we talk about here on this slide the owner's entitlement. You know, how is entitlement established for the owner? Well, it's similar in the same kind of consideration for the contractor. is first established by deciding whether or not the work was reasonably inferred in the contract documents. Was it necessary, as Doug described it, to be a component for the work to be complete? And so in considering that, the owner may or may not have a valid claim based on their entitlement under that kind of a definition. If it should be determined that the work is reasonably inferred, then the owner's claim may be upheld, and their claim potentially would be that there is no additional cost to the work that they received from the contractor. Doug, anything to add to that? Owner's entitlement?
Not really. I would say that the owner is, at this point, the one that's holding the funds. And so it is really incumbent on the contractor to make sure that they are documenting everything and submitting stuff in a timely manner, because the owner's recourse is always to withhold payment. And then it's on the contractor to seek legal action to get that payment out of the owner. So the owner's kind of in a superior position, kind of has the upper hand. So just a caution to contractors to make sure that you've got the stuff documented and are in a position, if you have to go to that next step, to be able to do so.
Well, Matthew, let's go to the next slide and talk about how can we avoid this mess that we've been talking about so far. Doug and I talk a lot about expectation management as a part and a component of what we do in the construction phase. And I think to avoid dispute, the first really important step is to understand and accept the fact that there are going to be changes, there are going to be disagreements that are a part of construction, and there are going to be claims as defined as a change in the contract amount. There are going to be claims that occur on a job. Don't fool yourself and think that it's not going to occur, and if it doesn't occur, celebrate that in great fashion, because it doesn't happen very often. And then the second important step is understanding that there are going to be changes. Then understand, put yourself in the shoes of, and be very familiar with what the interests and limitations are of these other parties to a contract. The consideration of what liability is undertaken by other parties, the scope and or amount of contract that they are dealing with as a part of their work to the project. Really have an understanding and you know, what control does a party have to the schedule, for example, and how that's limited for a subcontractor or a sub-subcontractor. You know, if you're really paying attention to these specific interests or limitations to the parties, then you're going to have a better global view and understanding of how not to get into a dispute as the project moves forward. You know, the owner has to understand, for example, that the contractor's cost, if we're talking about a design, bid, build kind of delivery system, are based on what's reasonably inferred, and that can be seen and be seen clearly at the time of pricing. If you've never been in a contractor's office while they're putting a bid together, I suggest that you find a contractor friend who will let you behind the door to see what that's like. Now, does that mean that there are mistakes because they go through that process in the last minute should be accepted? No, not saying that, but certainly a recognition of what they go through at the time of pricing should be in our minds as we consider what these claims may be. And from the contractor's perspective of understanding of the owner's position, you know, they've got to understand that controlling costs is critical, that depending on the type of project, opening on time can mean very serious dollars and cents on a daily basis if it doesn't occur. That, you know, if things are going to change, in a chain example, there are people up the ladder who have to approve additional monies being spent, whatever the organization is, whether it's a public school system or not. You know, these requests have got to be well documented so that the request for more funds or more time can be shared and approved by other parties, maybe, that are a part of the contract. And then, you know, the performance of that contractor really drives all these things. So the owner's counting on that. And from our perspective, the architects and engineers, you know, we've got to understand that we're expected to act in a timely fashion, and that the contract documents that we're looking at, we've got to be impartial about our review, and we've got to act with integrity and a sense of accountability. You know, perhaps I would stop from saying we have to raise our hand when we made a mistake. We avoid the words errors and omissions because we're afraid of them and they cost us money. But we have to act with integrity. So these are important understandings one party needs to have of the others as we try to operate in a fashion to avoid disputes on a project. Doug, is there anything?
I would just add that if you do get into a dispute, don't take it to a personal level. Keep it on a professional business level. I have seen several instances where people get so emotionally wrapped up in the project that they can't see the forest for the trees. I'm thinking of a project in particular where the guy I had doing construction administration and the superintendent and the project manager on the contractor side, they were like oil and water. They could not agree on anything. If one said it was raining, the other one said no, the sun was shining. And they let that get in the way of them accomplishing the goal and get the project done. And it got to the point where I ended up calling the owner of the contracting company and asked him to remove his PM and replace him, and told him I was doing the same on my side. And what ended up happening was I just took over the project and he took over the project. And in no time, we resolved all the disputes and got the project moving and got it done in time for the owner. So be aware of those personality conflicts, and just those need to be totally taken out of the equation. Matthew, can we?
Oh, we have 2 questions here from the audience. First one, any words of wisdom for the less experienced owner who takes the view that any changes or claims on a project are all the fault of the incompetent AE?
It seems more and more now that anytime that there is a change order that the owner thinks, and sometimes the contractor thinks, that the architect has to pay for it. Just educating your owner up front that there will be changes. Let him know the standard of care for our profession is not perfection. We are not expected to be perfect. There should be a contingency that's adequate for the project, and if it's a renovation project, the contingency should be higher than if it was a new construction project, and that contingency is to deal with not only unforeseens and owner changes, but it's also there to deal with the errors and omissions that may or that will be in the documents, because they will be there. I've had and we're running out of time. I didn't think we were going to get through all of this, but we've only got a couple slides left. But I'm going to keep going with the story. I've had an owner on a couple of different occasions, a couple of different owners, write letters to me saying, okay, here's this change order. Either you're going to write me a check or I'm going to withhold payment. And I have responded back and explained to him, well, that's not the standard of care. It wasn't to the level that it was negligent. There was betterment involved. Betterment is where if something's missing from the documents, the owner doesn't get a windfall because it was missing and the architect has to pay for it. So there's that betterment issue. I've written letters back and just explained the situation. I've also included articles that I have collected over the years that talk about who pays for change orders and why, and it goes into betterment explanations and the standard of care. And every time I've done that, they've understood and come back and have not asked us to follow through on their original request to pay for the change. That's not to say, I'm sorry, that's not to say that every time that you're asked to pay for something means you're not going to have to pay for something, because there are negligence issues where you may be at fault and may need to step up to the plate and pay.
I was going to say, I think this is a conversation we need to continue to have, and whether we get to these other slides, Matthew, let's be sure we get the questions asked. I would add briefly to Doug's that your professional organizations like CSI or EJCDC or AIA may be a good resource to obtain information to share with that owner in a, as Doug just defined, in an educational way. Sometimes they don't know better. You know, somebody has told them this, and so they believe it, and just a little education will go a long ways. So you might be able to refer to your professional organization for some assistance and written information that you could share with them, you know, in a non-confrontational way to help educate them. Matthew, what was the, do you have another question?
Yeah, we just had a comment here from the tweet chat from Sharice Schachter saying her 2 cents, she tends to encourage owners to try to get CSI certified just as a way of helping to educate them along that process. And then we had one additional question here from Michael asking, is arbitration a good method to be used to settle unresolved claims? How does this compare to litigation cost-wise?
Jim, I think those are some of the slides that are coming up.
They are. They are.
So shall we address that as we?
Sure.
As we
let's
go through.
Let's go to the next. Yeah, let's go to the next slide, Matthew. I don't know who that was that said get their owner to join CSI, but that's a great idea. That's a great idea. So, in resolving and settling disputes, you know, often they come out of the fact that one or other or more of the parties don't want the decision to be as the initial decision maker has rendered, and that there has been an attempt to negotiate and that has failed. You know, it's, as Doug said, this is not personal, it's professional, and they can occur, disputes, no matter how reasonably the party has handled the original claim. So as Doug just defined, there's personality that's to be mixed in this. The contractual provisions establish how we handle dispute management, and this goes to the point of the question raised. There are other means. AIA document A201 states that, you know, either party can file for mediation. EJCDC C700 has mediation as a first step. Doug, there's a fire truck that's coming down the road here, so I'm going to mute my phone so y'all can hear. Maybe would you mind picking up right here? And I don't want to blast y'all out.
Yeah, and Matthew, if you can just jump to the next slide. It talks about alternative dispute resolution, and it talks about arbitration first. I'm going to mention mediation before arbitration. Mediation is where you have a impartial third party that's agreed to by the parties that are in the dispute, and that person's role is to try to get the two parties to come to a mutual understanding. They're not a judge. They don't make a determination as to who's right or who's wrong. What their role is to try to facilitate a resolution between the two parties, which is different than arbitration, where arbitration is where you have a panel usually of 3 people that, again, typically is one is selected by one party, one is selected by the other party, and then the third is agreed to by the two parties to the dispute. And that panel hears from both sides, and they make a ruling or make a determination as to who's right or who's wrong, or what the finding will be.
Hey, Doug?
Yes.
I'm sorry to interrupt you. Let me ask this. Do you think that maybe we should grab this dispute resolution in alternative means and maybe expand that a little bit and go through some detail of that next month?
We could do that because it is just about 1 o'clock, and we can just pick up next month and talk about alternative dispute resolution processes.
Maybe, Matthew, what do you think?
That works for me.
So you kind of got a preview of the response to your question, and we'll just finish it up next month.
So with that, I guess if Jim and Douglas have anything else you want to wrap up for today, we can go with that then.
Well, just a little further look ahead after we talk about dispute resolution next month. The following month, we'll talk about project closeout, and that's something that has come up in our past discussions, and we had promised that we would address that. So that would be in April. So if you've got any questions on either dispute resolution procedures, alternative dispute resolution procedures, or closeout documents and record drawings and closeout procedures, please feel free to email those in so we can be sure to try to address them over the next couple of months.
All right. Well, with that, everybody, we appreciate your attendance in today's call. Thank you very much, and we look forward to seeing you on March 26th for the next one. And then I am just checking here to make sure. It looks like, tentatively speaking, we will be shooting for April 16th for the next one after that, but we'll find out and let you all know in email like we normally do beforehand. So with that, everybody, you can disconnect if you haven't already, and we look forward to seeing you next month. Thank you.